If you are watching Weather American, institutions can still restrain power. When the stakes turn dangerous, you need to take a moment to process what just happened. What unfolded in Washington was not a policy dispute. It was not partisan theater. It was a live test of whether the constitutional system still knows how to intervene when a president moves faster than the law. One vote, taken in silence, just slammed the brakes on a sitting commander-in-chief. Here is the moment that triggered everything. Early this morning, the United States Senate passed a bipartisan War Powers Resolution. That sentence alone should make you pause. The War Powers Resolution is not symbolic. It is not rhetorical. It is one of the few tools Congress possesses that is designed specifically for moments when lawmakers believe a president has crossed from authority into overreach. The direct target of that resolution was President Donald Trump, now serving his second term after returning to office in January 2025. And the reason was not abstract. It was Caracas. According to official accounts and subsequent briefings, President Trump authorized a sudden military raid into Caracas, Venezuela. The operation resulted in civilian casualties. It ended with the seizure of Venezuelan President Nicolas Maduro, and it was carried out without prior congressional authorization. Let me say that again so it lands properly. A United States president launched a unilateral military action inside a foreign capital, caused civilian deaths, captured a sitting head of state, and did so without Congress signing off. This is not normal. The Senate's response came fast. Not after weeks of hearings, not after months of leaks. An emergency session was called. Democratic leadership initiated the move. But the shock came from the other side of the aisle. A group of Republican senators broke ranks and supported the resolution. This is where you need to understand the context. The Senate does not reach for war powers lightly. It almost never acts this quickly unless lawmakers believe the executive branch is no longer self-restraining. This kind of institutional reflex only appears when confidence in presidential judgment has collapsed inside the system itself. And that is exactly what the behavior signaled. This was not framed as a disagreement over Venezuela. It was framed implicitly as a failure of internal executive control. Behind closed doors, senators described fear of unchecked military authority, not policy. Disagreement, authority. The resolution immediately activated the War Powers Act of 1973. That law exists for one reason. It was written in the shadow of Vietnam, when Congress concluded that presidents left alone would drag the country into wars the public never approved and lawmakers never authorized. The statute forces a choice. Either the president obtains congressional approval for continued military action, or the system begins shutting off oxygen, funding can be seized, orders can be contested, legal exposure begins to spread outward. From the Oval Office, this is where the system stops debating and starts enforcing. And inside the White House, according to executive branch sources, the reaction was panic, not outrage. Panic. Staffers reportedly scrambled. Communication slowed. Public statements softened. The familiar choreography of loyalty shifted into hedging. According to reports, some White House personnel began distancing themselves from congressional confrontation entirely. That behavioral change matters more than any quote. When an administration believes it still controls the field, it doubles down publicly. When it believes the system may be turning against it, it goes quiet. At the same time, the Republican Party's institutional centers went silent. The office of Mitch McConnell offered no defense. The Republican National Committee issued no
statement.
No coordinated counter-narrative emerged.
Silence in
Washington is rarely neutral. It usually means no one wants to own what comes next. This is where the event stops being about Donald Trump and starts becoming about the system reacting to Donald Trump, because the Senate vote did something more consequential than restrict a single operation. It opened a
pathway
for cascading challenges to presidential authority.
A
pathway that allows other institutional actors to test whether the president will comply, defy, or attempt to override legal constraints.
And each
option carries consequences that
compound.
Compliance freezes the foreign policy agenda.
Defiance invites
enforcement. Legal challenge escalates the conflict into the courts. None of those paths return the system to equilibrium. This is the initial meaning of the vote. Not removal, not impeachment, not collapse, but exposure. Exposure of how quickly confidence can evaporate inside a governing coalition when power moves without permission.
And
here is the part most people miss. Once Congress demonstrates it is willing to activate a hard constraint on war-making authority, it does not easily deactivate that posture. Every subsequent move by the executive is now interpreted through a lens of suspicion. This is where an incident becomes a pattern risk. The Senate did not just respond to Caracas. It signaled readiness to reassert Article 1 authority more broadly.
And
that signal did not land only in Washington. It landed in allied capitals, in foreign ministries, in defense planning rooms where credibility is measured not by speeches, but by whether orders survive institutional resistance. This moment did not end with a vote.
It began with one.
And beneath the surface, mechanisms are already shifting that most of the public has not yet seen. The vote did not fracture along ideology. It fractured along institutional instinct. 5 Republican senators stepped out of formation, and that detail matters more than the number itself. Rand Paul of Kentucky went first. Not quietly, not with procedural hedging. He went to the floor and framed the Caracas operation in the bluntest constitutional terms possible. Bombing another nation's capital and kidnapping their leader is an act of war. That sentence was not aimed at Donald Trump personally.
It was
aimed at the legal threshold the system recognizes as war, regardless of who orders it. Pause there.
That was a
senator from the president's own party, redefining the president's action as war. Inside the Senate record, Susan Collins of Maine followed with a different register but the same institutional signal. I cannot support unilateral strikes that risk American lives without debate. She said after the vote that line matters because it invoked process, not outcome. Debate is Congress's oxygen. When a senator says it was bypassed, she is accusing the executive of shutting off a co-equal branch. Lisa Murkowski of Alaska did not deliver a headline quote, but her vote carried its own history. She has broken with Republican presidents before, and each time it has been over institutional authority, not party loyalty. Todd Young of Indiana, a senator with national security credentials and intelligence experience, joined without theatrics. That silence was its own indictment. And then there was Josh Hawley of Missouri. This is where the system really noticed. Hawley had been widely seen as aligned with the president's populist wing. His vote signaled not just dissent but recalculation. When a perceived loyalist affects on a war powers vote, it tells the system that allegiance has limits. When constitutional exposure rises, the tally came in at 52 to 47, a razor-thin margin. But margins matter less than composition. This was not a Democratic rebuke with Republican noise. This was a bipartisan trigger pulled deliberately. Here is the shift most people miss. Once that vote landed, the White House was no longer dealing with opposition. It was dealing with activated mechanisms. According to internal accounts, President Donald Trump reacted with fury. Reports describe isolation in the Oval Office. Phones were picked up personally. This was not delegated outreach. The president called the defectors himself. Rand Paul reportedly ended his call after roughly 30 seconds. No negotiation, no cooling period. That matters. It suggests the conversation never entered persuasion territory. Susan Collins listened. Sources say she did not concede ground. Listening in. This context is not weakness. It is a refusal to escalate emotionally while holding position institutionally. Josh Hawley's call carried the sharpest edge. According to reports, he was warned that he had just ended his political career. That threat reveals more than anger. It reveals an assumption that party machinery could still discipline institutional defection. The vote itself had already disproven that. Shortly after the president went public on social media, he accused the senators of cowardice and declared they were destroying the strength of the United States. This was not messaging aimed at Congress. It was aimed at the base. That distinction matters. When a president speaks to Congress, he uses leverage. When he speaks to supporters, he is seeking insulation. That tells you where he believed the pressure was coming from. Then the conflict moved arenas. The White House filed an emergency motion with the D.C. Circuit Court of Appeals. The request was straightforward: block enforcement of the War Powers Resolution. The argument was not subtle. Administration lawyers claimed the War Powers Act of 1973 itself violates Article 2 of the Constitution. In other words, Congress never had the authority to restrain the commander-in-chief this way. This is where the clash stops being political and becomes architectural. That legal theory has existed on paper for decades. Presidents have grumbled about war powers limits. Few have dared force the judiciary to rule on it in real time, under active military conditions. And then the Supreme Court responded. The court announced it would take up the emergency appeal on an expedited basis. Oral arguments were scheduled quickly, a pace reserved for moments the judiciary believes delay itself would destabilize the system. Chief Justice John Roberts issued a rare public statement. The judiciary exists to resolve disputes between co-equal branches without favor or fear. That sentence was measured. It was also a warning. The court was signaling that it would not serve as an escape hatch for either branch. This is the moment the conflict fully triangulated: executive, legislative, judicial, all engaged. Meanwhile, Congress did not wait. In the House, leadership began preparing options to cut off military funding tied to Venezuela. This is the sharpest tool available short of impeachment. The Oversight and Armed Services Committees moved to issue subpoenas for planning documents related to the Caracas operation. Paper trails are not symbolic. They are how institutions build enforcement narratives. While that machinery turned, the markets reacted. Dow Jones futures dropped by roughly 800 points. The S&P 500 fell 3.8%. Oil prices surged past $15 per barrel. Markets were not reacting to ideology. They were reacting to uncertainty about command authority and regional escalation. Internationally, the signal was received just as clearly. NATO convened emergency discussions. According to diplomatic sources, allies began scenario planning around reduced United States reliability in unilateral security actions. That is not a public rebuke. It is worse. It is contingency planning. At the United Nations, the Security Council met at the request of Russia and China. France and Germany issued a joint statement calling for de-escalation and respect for international law. The language was Careful. The implication was not. This was no longer about Venezuela. This was about whether the United States could still coordinate its own power internally before projecting it externally. Every actor involved understood one thing. Once war-making authority is contested in public, it does not quietly reset. It either reconsolidates under law or it fractures into precedent. And the system had just crossed the line where precedent becomes possible. Because from this point forward, every order, every deployment, every dollar carries a question behind
it.
Who is actually in control? And whether the answer still holds under pressure. What began as a political dispute has now hardened into something far more rigid. The crisis has crossed a threshold. It is no longer about rhetoric, messaging, or partisan alignment. It has moved from argument into structure, from disagreement into enforcement, from politics into institutional collision. And once a system enters that phase, it does not glide back to normal. Here is where the paths narrow. Analysts inside and outside government now converge around three possible trajectories, none of them clean. The first is compliance. The president could choose to observe the War Powers Resolution, halt further unauthorized military action related to Venezuela, and seek formal congressional approval. On paper, this restores constitutional balance. In practice, it freezes the administration's foreign policy posture. Momentum collapses. Authority recedes into process.
For a
presidency built on decisive action, this option carries an internal cost that extends far beyond Caracas. The second path is coercive enforcement. Congress has already signaled readiness. Funding restrictions are drafted. Committees have moved from oversight to compulsion. Subpoenas are active. If the executive resists, lawmakers are positioned to escalate without another floor vote. Budgetary pressure does not negotiate. It constrains. This route would mark one of the most aggressive reassertions of legislative war powers in modern American history. The third is full constitutional confrontation. That path runs through the courts, through contested orders, through conflicting claims of authority, between branches that were never designed to agree under stress. If this holds, the judiciary becomes the final arbiter of whether a sitting president can continue military action in defiance of Congress. That is not a legal exercise. It is a stress test on the system's ability to absorb institutional defiance without rupture. Here is the part that rarely gets said plainly. Once a president forces the system into choosing between obedience and precedent, every outcome leaves residue. Inside the Republican Party, that residue is already forming structure.
A
new bloc has emerged, informally referred to as the Article 1 caucus. Its purpose is explicit: defend congressional war powers regardless of
party.
This is not a protest faction. It is an institutional alignment, and it signals that loyalty is being recalculated around branch authority rather than presidential proximity. That shift matters because it is durable. Parties recover from losses. Institutions remember breaches. On the streets of Washington, the temperature has risen accordingly. Tens of thousands have taken to demonstrations across the city. Some defend the president's actions as necessary strength. Others frame the Senate vote as overdue restraint. The National Guard has been placed on readiness, not as spectacle, but as contingency. The system is preparing for sustained instability, not a single news cycle. Internationally, the consequences compound quietly. Allies are not issuing ultimatums. They are doing something more consequential. They are reassessing reliability. When NATO planners quietly explore scenarios that assume diminished United States predictability, that is not protest, that is adaptation. When adversaries exploit visible division to test boundaries elsewhere, that is not opportunism, that is strategy. The credibility cost does not announce itself, it accumulates. At home, the political reality is stark. The Trump administration's foreign policy agenda is effectively paused, not defeated. Paused. Every move now passes through congressional filters that were dormant weeks ago. That is not gridlock. That is reversion to constitutional design under duress. This is where the narrative must reset. This is no longer a Venezuela crisis. It is no longer a referendum on Donald Trump's temperament or judgment. It is a direct examination of whether the American constitutional order still functions when one branch refuses to.
Slow down.
And here is the irreversible
Part.
The system has revealed its willingness to confront executive power openly. That signal cannot be retracted. Even if this specific conflict de-escalates, the president remains available. The next president will inherit not just authority but memory. Congress has rediscovered tools it had allowed to rust. Courts have been pulled back into first-order constitutional arbitration. Markets have recalibrated around institutional uncertainty. Normal has already been displaced. Every next step from here is legal, coercive, and binding. There is no